can expect for the balance of the week. So with that, we'll turn this over to Natalie Scott and ask Natalie to provide the committee with a review of the content of 2147.
Thank you, Mr. Chairman. House Bill 2147 allows early discharge from prison for certain drug offenders. The bill creates a new provision of law to provide that on application by an offender in the custody of the Secretary of Corrections who is serving a sentence for only a severity level 2 through 5 drug crime, or a sentence where the primary crime was a severity level 2 through 5 drug crime. The Prisoner Review Board may grant release to probation for the remainder of such offender's sentence if the offender has successfully served 50% of the prison part of the original sentence. The board shall examine each application and shall not approve an application unless the board determines that the offender does not represent a future risk to public safety. The bill also requires the board to establish conditions related to release of the offenders that are released under the program. If an offender released pursuant to this section fails to comply with probation, or the board finds the offender presents a threat or risk to public safety, then the release would be then subject to revocation. The district court in which the offender was convicted shall have jurisdiction over the offender, and revocation shall not be subject to the provisions commonly referred to as justice reinvestment in KSA 22-3716C1. Those are what we kind of talk about as the dip and dunk provisions. Dips now only. Offenders released under this section shall be supervised by community correctional services. The board's decision regarding release shall be final, and in making that determination, the board shall consider whether 50% of the sentence was served, the risk or threat to public safety if the offender is released, whether a release plan has been established for the offender, whether the offender has completed all programs required by the Department of Corrections, and any other factors deemed relevant by the Prisoner Review Board. This section shall only apply to offenders directly sentenced to prison and not those who are in prison because of a probation revocation. An offender may make an application pursuant to this section once during their sentence unless the board allows subsequent applications. This section does not apply to offenders sentenced to prison for off-grid offenses or sentenced to death or life without the possibility of parole. Section 2 amends KSA 22-3716 to make conforming amendments to provide that offenders released to probation pursuant to this new Section 1 provision shall not be subject to the revocation provisions in subsection C1. And I can take any questions.
Any questions for the reviser? I see no hands. We will move on then with proponent testimony. We'll call upon Randy Bowman with the Kansas Department of Corrections. Mr. Bowman, good afternoon. Welcome. It would appear that maybe Mr. Bowman isn't on with us at this point. He may join later. If not, committee, you have...
I think he's here, Mr. Chairman, actually. He's at least on my screen. Oh, but we can't hear him, so I think he's working on his sound here.
Okay. Yeah, I see Randy. Looks like you are here, but we're not getting any audio from you.
Sometimes it helps to disengage the video to get to the audio.
Any audio yet?
There you go. And Randy, I would suggest Representative Baker is probably right. If you would maybe turn off your video, I think it helps with your bandwidth over there. You don't always come through as clear as you might with the video on. There you go. Okay, go ahead and proceed.
Yeah, sorry about that, Mr. Chairman and members, but yeah, technology is great until it doesn't work, I guess is how it's being said in this day and age. So you have my written testimony there before you, I hope. Yet another policy choice before you that's presented by Sentencing Commission and others, it gives a good option to consider what level of investment is important to make in the actual incarceration instead of other options for certain drug offenders. What from our lens is a little bit different about this one that I wanted to just call to your attention appears in paragraph 4 there. And that's the provisions that Natalie went over where the person can apply to the prisoner review board for that release after that 50% threshold has been met. And our prisoner review board took a look at this and they estimate that they might have around 450 hearings per year for this. And then kind of like we talked last week, even though the Sentencing Commission says this has about 59 fewer persons in prison, when we look at our marginal costs and look at these folks coming out of 2 or 3 a unit here or there, we really don't develop much measurable savings from our institutions. So we basically kind of think this could be more or less a wash. We might save a little bit in our prison system, but we may have to look at staffing for the prisoner review board that we use volume. But that aside, we do support this bill. We think it's another good option for consideration by you as a committee, and if you see it favorable by the rest of the Kansas legislature. So with that, I can just stand for questions at the appropriate time.
Thanks, Mr. Bowman. Representative Carmichael, your hand is up. Is there a reason?
At the appropriate time, I have questions for Mr. Bowman.
Very well. I think we'll hold questions until all proponent testimony has been provided.
I understand. Thank you.
Thank you, sir. All right. We will move on now to Scott Schultz, Executive Director of the Kansas Sentencing Commission. Mr. Schultz, good afternoon. Welcome.
Good afternoon, Mr. Chair, members of the committee. Can you hear me all right?
Yes, sir. Thank
you. Thank you for the opportunity to testify in favor of this particular bill. This is being brought to you by the Sentencing Commission. This is set to incentivize nonviolent inmates sentenced for drug crimes by releasing them to community corrections for the remainder of their sentence. So this is more of an out-of-the-box type of proposal for this committee to consider. What essentially happens is if these are folks that have not been on probation before, they are direct commits to prison. If they actually do what they are supposed to be doing at the 50% part of their sentence, once they've actually served 50% of their sentence, they can actually make application to the Prisoner Review Board, and Natalie went over that a little bit. But again, looking at incentivizing incarcerated offenders for them to actually, there are occasions where folks are actually doing what they need to be doing while they're in prison, and that in particular, as far as drug crimes are concerned, they could actually be out sooner. And this particular provision provides at that 50% mark, they can actually make application. It's not a given, certainly, because the Prisoner Review Board, who also, as many of you are aware, Prisoner Review Board actually releases on parole and makes those parole decisions on the worst of the worst folks coming out of prison. They would do a similar analysis here in looking at whether they've served that 50%, the risk to the or threat to the public safety and the community if released, whether they have an appropriate release plan that's been established for them, whether or not the offender has completed all the programs required by the Department of Corrections, and any other relevant factors that the PRB would consider. So this is obviously going to be just for those folks that are in compliance with those terms and conditions of their incarceration. And instead of releasing them, what would normally happen is an individual would be released to post-release supervision and supervised by parole. This is a little twist in that this would be these folks would be released to community corrections instead to do the remainder of their sentence. Well, why do that? This was something that was discussed in the commission. It was believed that in many of the places statewide, having community corrections resources available to these folks will probably be more substantial than possibly on if they were placed on parole in a post-release supervision capacity. So again, this does not apply to folks that have been convicted of off-grid offenses such as homicide, child sex crimes that would qualify for that. It does also not qualify for those folks that have been revoked, their probation's been revoked. They would not be eligible for this as well. Again, in this situation, the Prisoner Review Board would act as the gatekeeper to determine whether these folks would be eligible and would be a public safety, wouldn't be a public safety risk to release them back into the community where then they could actually receive treatment as well as become gainfully employed and not be incarcerated. If they are non-compliant, they can be revoked just like a normal probationer would, absent and wouldn't have to go through the graduated sanction process. They could automatically be revoked back to prison. The bed space impact is there for you. Again, this is for drug level 2 through drug level 5 folks. The commission thought that D1, which is manufacturer, shouldn't be eligible. And so we have D2 through D5 as being eligible under the current drafting of the bill. The bed space is set at about a little under 60. This is presuming that everybody would be potentially eligible. Of course, that's probably not going to be, because we don't know what the anticipated release number would be from PRB at this point. That would probably be a little high. So with that, I would stand for any questions at the appropriate time, and thank you.
Thank you, Mr. Schultz. We'll move on to our final listed proponent testimony, Kendall Seal, Director of Advocacy with the ACLU Kansas. Mr. Seal, are you on?
Yes, I'm here. Can you hear me?
Yes, I do. Go ahead and proceed.
All right. Thank you, Chairman Jennings, members of the committee. My name is Kendall Seal, Director of Advocacy for the ACLU of Kansas. We support House Bill 2147 as a positive step toward a more just and equitable criminal legal system. Although we support the bill as written, we offer a few amendments to strengthen the bill's impact on low-income and minority communities in Kansas, which remain particularly susceptible to Kansas's discriminatory drug laws. First of all, we urge you to amend the bill to expressly prohibit the Prisoner Review Board from considering whether someone has paid all of their fines, fees, and restitution, and determining whether 50% of their sentence has been completed. Fine, fees, and restitution are major barriers to people completing their sentences. And as it stands, this bill gives the PRB authority to determine any other factors deemed relevant, which we believe is overly broad. Fine, fees, and restitutions should not be a part of this analysis because those in particular perpetuate racial disparities in the criminal legal system. As we've shared with the committee before, people of color account for 33.6% of drug arrests, yet they represent only 23.9% of the state's population, in particular Black Kansans. That racial inequity is even starker. These financial barriers are especially harsh for people of color because of the long-standing racial disparities in wealth and poverty that perpetuate cycles of debt and instability. Next, transparency is needed regarding the PRB's decision. This bill should include provisions mandating the PRB release statistics or reports on the number of early discharge applications it receives each year, how many have been approved and denied, and the reasons for denial. The PRB should release statistics on the number of revocations and the reasons for revocation. As currently written, this bill will have some unintended consequences because it opens up the possibility for the PRB to set conditions of probation that are arbitrary, onerous, and unmanageable. Even the Kansas Criminal Justice Reform Commission Subcommittee on Community Supervision recognized the unintended consequences of over-supervision and too many conditions of probation. According to the current text of the bill, the PRB set the conditions of release and has the authority to revoke probation for a single infraction. This is problematic because, as we've shared before, we believe the Kansas probation system places unnecessary barriers to reentry. Again, we would urge the committee to pass AB 2147 with this amendments, and I'm happy to answer any questions the committee has at the appropriate time.
Thank you for your testimony, Mr. Seal. Committee, I have no other listed proponents today. Are there any others wishing to speak in support of this bill? I see none. We'll proceed then with committee questions of proponents, beginning with Representative Carmichael.
Thank you, Mr. Chairman. Questions for Mr. Bowman, if he's able to hear me.
I can.
Very good. I noted in your testimony the very point that you brought up in your oral testimony, and I'm looking at it now from the fiscal note that we have from the division of the budget. But first, can you tell me how the Prisoners Review Board reached its estimate that there will be 450 hearings per year as a result of this legislation?
My understanding is they were looking at some of the data on the numbers of persons in the facilities that they think fit the criteria based on a thing.
Well, with respect, I understand that's how they do this, but how many people were eligible? How many of them do they anticipate will file for hearings? Will they be filing for hearings every year, or is it just a one-time backlog during the first year?
My understanding is they're looking at it, that would be a number annually. So not a backlog necessarily.
So they anticipate 450 hearings per year. Is that correct?
Year. That's my understanding.
Okay. Can you provide us with some background information or explanation as to why it is it's 450 hearings, not only the first year, but every year?
My thought would be that they probably didn't look at the data in terms of any backlog that's there now. They just looked at an estimate per year based on per year data.
Well, then what is the cost per hearing?
Well, I don't think we could calculate for you a cost per hearing. What I can tell you is that their current workload looks a little bit like this. For new law or current law, they look at about, last year it was over 4,700 release plans. Then for those old laws, those indeterminates, they looked at about, last year it was a little over 550 of those. So if you call it round numbers, 5,300 cases they're reviewing every single year, this would add somewhere around 10% to that.
And so what is the financial impact of that additional 10% in the number of hearings?
We have not tried to calculate a per hearing cost.
Okay. Well, the reason I'm asking you these questions, and here in a second, with the chairman permitting, I want to ask you about the incarceration costs. But in the fiscal note, your department says that any additional resources would offset potential savings generated by the reduction in inmate population. That's a pretty strong statement, and I'm trying to find out whether it's correct. But let's move then to the number of people who are being incarcerated and the savings from that. The first year estimate is 59, but I think at 10 years out, we're looking, if I recall correctly, it's somewhere around 209 beds. Yeah, 2031, 209 beds. How much per year does it cost to keep someone incarcerated?
So the marginal cost per day for a person in fiscal year 20 was about $10.18. So that is the food cost, the clothing cost, some of those types of items. The total cost, if look at everything, cost of facility, cost of staffing, et cetera, is $82 and change. That's the exact figure.
Okay, $82 per prisoner in state prison. What is the cost per prisoner in community corrections?
About $7.
82 versus 7.
So 82 cannot be realized with 59 persons. We would have to have enough people not in prison to close an entire unit. And those folks would have to be of the same gender, the same security risks, the same background. They would all actually come from the same unit. So that's what I was trying to explain and didn't do adequately. My apologies. When I said 59 folks would come from this unit at one facility, 2 or 3 from another unit. So it doesn't allow us to close the entire unit. And if we take a unit of 100 to 200 people, take out 2 or 3, we can't realize any savings to the cost of the facility. We can't reduce staffing, those types of things. So we encourage the committee to look at the marginal cost, which is gained in that. So $10 a day, less community corrections at $7. Yeah, we didn't exactly $3 for the prisoner review board, but there is a cost there as well. That's why our comment was that it would be probably kind of a wash in cost for us.
Well, Mr. Bowman, there's an old saying, and I can't quote it exactly, but you know, a dollar here, a dollar there, at some point you're really talking about real money. And I don't think you're looking at these debt savings and the financial savings in the aggregate. You're looking at them one individual bill at a time. And Mr. Chairman, I just have very, very little confidence in the financial impact statement that the Department of Corrections has provided us. I would hope that they would have more backup before they reach this type of a conclusion. Thank you, Mr. Chair.
Thank you, Representative Carmichael. Representative Owens.
Thank you, Mr. Chairman. Scott, question for you, maybe. Can you tell me how this is different from the bill where we were talking about good time credit and, you know, significant reductions in good time credit? It appears to me that this is just kind of an end around different approach at accomplishing the same thing.
Mr. Chair, Representative Owens, this is a situation in which you are in a drug context, good time as well as a non-drug context. Good time is by statute already awarded, that either being 15 or 20%. This allows on these particular certain drug offenses, allows for them to actually petition, not, you know, it's not a mandatory situation. Just to kind of give you an idea, this is this kind of arose several years ago from our chair had received a letter from an inmate that he obviously could not do anything as far as being actionable about it. But what had happened is she had actually completed all of her programs, paid all of her costs and fees, restitution that was due and owing, and she still had a half left of her sentence. And there was basically all that she was doing was spending time in prison before her release. After she had gone through, been proactive in completing all of her things that she needed to do. And so this was earmarked for this particular situation, was based upon those folks that are actually doing what they're supposed to be doing. And obviously, isn't that what we're asking them to do while they're incarcerated, is to make sure that they've paid their costs, paid their debt in whatever capacity, and are ready to get out and resume life on the outside. So yes, in her situation, she would have a good time credit type situation, but at the same time, this allows for them to at least petition, and if they've completed everything, then that gives them an opportunity to be able to be released. Now, keep in mind, they're still under supervision. They're still under supervision by community corrections. They just are not incarcerated.
All right. Thank you, Scott. Appreciate it. Thank you, Mr. Chairman.
Representative Day.
Thank you, Mr. Chairman. I think this question is for you, Scott, as well. So I have a specific person in mind. Just keep that. I don't know the exacts of their situation, but I know some generalities of it. So if a person has a previous offense that is, that I think was domestic in nature, that was considered when they were sentenced for their drug conviction, but is unrelated otherwise, would that person be eligible for this situation, for this bill to help them with the early discharge? Again, keeping in mind, I'm not sure how bad the domestic offense was that was considered in their sentencing, but I know they weren't sentenced for it originally. It just came in for consideration when they were caught and put in prison for their drug offenses. So I'm just not sure how that would impact things. Would you be able to help me figure that one out?
Mr. Chair, Representative, the not knowing what that domestic is, certainly felony domestic battery is an off-grid or a non-grid offense, so they would be serving any time regarding that in a jail setting. So they don't, domestic battery is not served in prison. So if it were related to domestic violence or something of that nature, it could actually have what's called a DV tag. In this particular situation, we're looking at people that are just charged with this crime, or that the primary crime is a drug level 2 through level 5. So that would be the overarching crime. There may be secondary crimes that may be involved, but the primary crime is normally what the court sentences to the full sentence, what they fall on the grid. All the rest of the crimes actually fall back to a criminal history I score. And so there's nothing in here that and maybe somebody can bring it up, but it doesn't appear that there's anything in the bill that would preclude what you're talking about. But that would just be something that we'd have to look at to make sure.
Okay, and that's what I was, I'm just considering, what we would hear from the opponents and keeping that in perspective. So I was wondering how that person, because there could have been violence in the past, like you're saying, it wouldn't have been enough for them to be put in prison for that offense, but for it to later be impacting this. So thank you so much. I appreciate that. Thank you, Mr. Chairman, for allowing me to ask my question.
Mr. Chair,
Representative Owens, Representative Day, if you want to lower your hands, that would be dandy, unless you have additional questions. And Randy, I've got just a couple, and so you're going to begin probably to notice a reoccurring theme, one that aligns, I think, a little bit with Representative Carmichael. We know from reports from the Sentencing Commission and from the Secretary that prison inmate population, which was once at about 104, 105% of capacity with over 10,000 inmates, is now down in the mid 80% range with about 85, 8,600 inmates. Pretty substantial drop. We know that we have any number of bills before us this year that would seek to influence the number of commitments to prison on the one hand, and perhaps provide for an earlier than otherwise would have been expected release, all of which theoretically would reduce the prison population even further. So I guess the question I have is, at what critical mass do we arrive at a point where reduced inmate population achieves something closer to $25,000 a year savings rather than $10 a day or $3,000 a year worth of savings? Does the department have any idea what it takes to achieve the point that actually real savings might be realized and real dollars might be available to invest in other areas that could lead to even further reductions in greater public safety?
Yeah, that's a great question, and one we struggle with in our conversations in here as well. At the end of the day, though, to do my best to answer that question, we'll keep trying to educate the committee and others that we simply have shoved a lot of people into less space for a decade or greater, and we think there's great value in keeping the same amount of staff, the same amount of bed space as a facility, so we can spread a lower number of persons out amongst those is good for the safety of the residents, safety of the staff, and good public health in this COVID time, and we'll have, that risk for the foreseeable future. If there are 10, that's a bad number. If there are 4 or 5 bills that get passed and you can aggregate all those numbers together and go, okay, these bills as a package impact maybe 500 people, we'd be happy to go calculate additional figures for anybody who needed them. It's just the challenge of the process. We look at each of these in isolation because that's the way the fiscal notes work. And we don't get that opportunity to aggregate it together. But we would like to have the space to spread folks out. We have a lot of 2-person, 3-person, 4-person cells, even at 8,700 today.
Thank you. Thank you for that. And I appreciate that. I just hope that the Secretary can appreciate that at this end of the block, there are definitely people that are interested in understanding how it is we can have such a significant reduction and still achieve no savings. And then again, we're not a budget committee for you, but as you know, I kind of look at budgets a little bit, and there's an item within the agency budget that I think historically has related to operations that were well above capacity and causing problems. That was with outsourcing of inmates. The department still has $2 million within the budget for placement of inmates in facilities other than the Department of Corrections. It just seems on the surface that perhaps those funds might not be needed for that purpose and could be redirected to support expanding Senate Bill 123 community-based treatment programs. Do you have any sense of that?
So yeah, I think what you're referring to there, Mr. Chairman, is the money that's for county jail placements and probably includes, no, scratch that, probably doesn't include those women at the state hospital, probably just the jails. So yeah, that's another option. If that's what was ultimately decided by the budget committee, there would be the space if we want to bring those in and still have that phenomenon of 2, 3, 4-man cells in a lot of places. We could bring new people back from county jail.
Do you know offhand what the charge for county jail placement is? Isn't it like $35 a day or something?
I think on the low end, and it varies by the reason the person's there and to some extent each jail, but it's in that high 30s to $50 range is my immediate recall.
And I'm curious, do you know whether the Secretary or the administration generally feels any compulsion to support county jails by providing inmates to afford them a revenue stream to support their county operations?
I do not know that, but you're right, it would be an impact for those jails.
Committee, any other questions? I see none. We will move on then from proponent testimony to opponent testimony. Call upon Greg Smith. Mr. Smith, welcome. And maybe not welcome. I don't think I see Greg on my list. We do have his written testimony. I will simply go on to commit that written testimony for consideration by the committee. We have Ed Klump listed as written only testimony. If that's an error, and Ed, you're on, please speak up, but otherwise we will accept and consider that written testimony in opposition as well. I don't hear anything from Ed. That is the opponent testimony that I have listed. Are there others wishing to testify in opposition to House Bill 2147? See and hear none. We have no neutral testimony. Anyone wishing to testify neutral on House Bill 2147? I see and hear none. Therefore, we will close the hearing on House Bill 2147. Committee, we've had a couple disruptions this week, weather related. I certainly appreciate everyone's attendance and utilizing technology to help us make use of at least part of today. just to give you a little bit of heads up, tomorrow we have scheduled for hearing House Bill 2274. We will also seek to work House Bill 2191 and House Bill 2144 and have a committee discussion on the three bills that I previously mentioned that I'd like to at least have a conversation and kind of get a sense of the direction the committee desires on House Bill 2139, 2146, 2147. On Thursday, if we have not completed considering the bills that are scheduled to be worked, we will finish those up, and we have bill hearings on House Bill 2275, 2277. I would just say that as we go into our final week of committee meetings, there will be a couple of hearings, but I anticipate trying to go ahead and work the bills that we've got left to work, and hopefully have that done during regular committee time, Monday through Thursday, barring any weather-related or other kinds of disruptions. We should be able to achieve that. I don't anticipate having to ask the committee to meet after hours. There's occasions we've met at 5 o'clock in years gone by. I think we can manage the workload pretty well. If you have any amendments that you're contemplating for any of the bills that we've heard thus far, I would encourage you to get with the reviser and get that work started so that perhaps they don't get loaded up the night before we're going to actually work bills, and we can kind of help them manage their workload a little bit. Committee, anything further from any committee members? Questions? Need clarification? Reviser, or you need any clarification? You good? Nodding up and down in affirmative. Great. Okay, with that then, we will adjourn the meeting and wish you all a safe afternoon and evening. Thank you.